I've taken a look at the Fifth Circuit Court of Appeals orders involving the pistol brace or the stabilizing brace issue being litigated against the Department of Justice and the ATF. I've got a lot of thoughts about it. We're going to peel back the onion here quite a bit in just a minute. Stay tuned. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the best-selling new book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. There's a lot of huge lessons over in that experience. I put it together in a short book, both available on Kindle and an audiobook. Check it out. It's a quick read. I think you'll find a lot of great information in there. Okay, folks, this is important. I'm not going to give anybody legal advice, but I'm going to flag a lot of the issues that I see that need to be considered. I'm not saying resolved, but considered in the context of these recent orders involving the pistol brace case out of the United States Court of Appeals for the Fifth Circuit and a Southern District of Texas case and a potential ruling, we'll see, out of the United States District Court for the District of North Dakota. All these things could impact the rights of those people that have stabilizing braces and pistols with stabilizing braces, and these issues that we've been talking about where the ATF, Department of Justice, almost certainly at the request of President Biden, is trying to harass law-abiding gun owners and turn millions of Americans into felons over holding some pistol brace silly item at the end of the day when it comes to public safety or whatever you want to say. Nevertheless, that is where we are. So let's talk about this. I want to remind you where we stand, and then I'm going to break down what's happened, and I'm going to talk about some of the considerations that perhaps gun owners and the lawyers in these cases may want to contemplate or consider moving forward. To begin with, as I mentioned before in prior videos, the 3 cases that I think are the most important for the pistol brace issue that you need to track. I think there's other cases out there, but in my view, there's only 3 that really count as a general matter to giving you some immediate relief. That's my best thought. The first is, of course, the case that I predicted was the furthest along and our best chance at victory, which was the Mock versus Garland case that involved the Firearms Policy Coalition and a company called Maxim Defense, I believe. Those were plaintiffs in this case against Merrick Garland, the Department of Justice. That was filed down in Texas, in the Northern District of Texas. The Northern District of Texas refused to enjoin the ATF's regulation involving stabilizing braces or pistol braces. That was then appealed on an emergency basis for an emergency injunction to the Fifth Circuit Court of Appeals, which is the federal appellate court that oversees 3 states. They oversee Texas, they oversee Louisiana, and they oversee Mississippi. Now, the reason why that's important is because the Fifth Circuit Court of Appeals, in a 3-judge motion panel, we'll talk about why that's somewhat relevant, not hugely relevant, but a little relevant, why the 3-judge motion panel entered an injunction on behalf of the plaintiffs named in that case. And those plaintiffs were William Mock, Christopher Lewis, Maxim Defense Industries, and the Firearms Policy Coalition. Now, the motion panel, just to let you know what that is, as opposed to the merits panel, which we'll get to. A motion panel is really just a group of judges that sit around in a given week or time to cover any emergency. So, for example, let's say it's a Friday night, everyone has gone home for the Memorial Day weekend. You're assigned to be on call, if you will, like a doctor on call. So if an emergency motion comes up seeking an injunction, for example, an emergency stay of a death penalty, you are the one on call to make that initial determination about whether or not to grant the emergency relief. You may not be the judge, or those judges may not be the judge that ultimately spends several months looking at the case and deciding it, but for that particular time, that Friday night on a Memorial Day weekend or on Christmas Eve, whatever it is, that's what a motion panel does. They're like on-call doctors. They're there taking in anything that comes in the door, so all the other judges don't have to worry about it. So the motion panel entered an injunction in favor of us in the Second Amendment, and specifically says that the plaintiffs in that case are protected from DOJ or ATF enforcement actions or any kind of enforcement of that pistol brace ruling. So that's what happened. Then what happened, wisely so, is the plaintiffs on behalf of the Second Amendment, the plaintiffs' lawyers filed a motion for clarification to the Fifth Circuit Court of Appeals saying, we want clarification. And specifically what they wanted clarification on was who exactly falls within the definition of the word plaintiff. Because as you know, when you're dealing with Maxim Defense Industries, which is a company, and you're dealing with the Firearms Policy Coalition, which is a nonprofit entity, they have customers and they have members presumably. And as a consequence, they said, well, we want to make sure that the members and our customers are covered as well, because from Maxim Defense's point of view, they're arguing that they're going to go out of business if this rule is enforced. So to stay in business, they need to make sure this rule is enforced against their customers, is enforced and protects their customers, I should say, because otherwise they won't be able to sell to customers because the customers won't be able to buy, and Maxim Defense Industries will go out of business, and that'll cause irreparable harm to them. And of course, the Firearms Policy Coalition says we're an organization, we're suing on behalf of our members, because presumably, I don't know a lot about FPC, but I'm guessing that FPC doesn't actually own any guns or pistol braces. I'm guessing the only people that they touch fingers with that have pistol braces and firearms and the like are probably their members, right? So with that said, they went back to the Fifth Circuit and says, we want clarification to make sure that our customers and our members are covered. And the Fifth Circuit Court of Appeals granted the answer yes, and they agreed with that. But this is where some interesting questions arise. Let me tell you what the Fifth Circuit said, and then we're going to break it down a little bit about what it might mean or what it might not mean. So specifically, and by the way, I'm going to put links to these orders down below so you can check them out yourself and see what you think and see what your counsel, your advisors, whoever you're working with to make sure you're in compliance. You always want to be in compliance with the law. We don't want you to break any federal laws or any laws because we want to make sure all American gun owners are safe and protected and law-abiding because we don't want any of you losing your gun rights or going to prison or suffering any penalties. We don't want any of that for our brothers and sisters in the Second Amendment movement. Okay, so this is what the Fifth Circuit says. They make a reference to the fact that the plaintiffs sought this motion for clarification, and they're going to grant it. This is what they say, quote, the appellants, which is the plaintiffs, acknowledge that although a nationwide injunction would have functionally addressed the questions of scope on which plaintiffs now seek clarity, the Second Amendment plaintiffs understand that one was not given. Instead, the Second Amendment plaintiffs merely request clarification on whether their reading of the term plaintiffs includes the customers and members whose interests plaintiffs' Maxim Defense and Firearms Policy Coalition have represented since day one of this litigation. You see what they're asking? They wanted to make sure that the customers and the members of these organizations whose interests they allegedly have been representing since day one, according to this, are covered under the definition of the injunction, are protected by the injunction. So the Fifth Circuit says in response to that, quote, that reading is correct. Also as requested, the term plaintiffs in this case includes the individual plaintiff's resident family members. Now, the reason why that's important is they wanted clarification to make sure that I don't own a pistol brace or anything like that, by the way, but if I did and I had a pistol with a pistol brace on it, I would not want any members of my family to have to go to prison for constructive possession of an illegal firearm, allegedly, right? So that is what that language is there for, okay? Now, where it gets interesting is who exactly is protected by this order outside of the named plaintiffs. Now, this is fascinating, and I'm going to flag some issues here. So the first question is, as a practical matter, the Fifth Circuit Court of Appeals covers, again, 3 states, Mississippi, Louisiana, and Texas. Let's assume someone is living in those 3 states, but they're not a member of the Firearms Policy Coalition. Would they be covered? Well, as a practical matter, I think the answer likely would be yes, and arguably protected. And why is that? Because you have the Fifth Circuit Court of Appeals is the highest court overseeing those 3 states involving federal law and the Second Amendment, right? And they're basically saying that we find that these plaintiffs are likely going to prevail on finding this pistol brace rule to be illegal or unconstitutional and unenforceable in these 3 states. That appears to be where this is going to, because keep in mind, the merits panel, remember I told you there was the motion panel, but it was the merits panel that made this determination to extend, continue, and expand, arguably, the scope of the initial injunction of the motion panel. Remember, the motion panel is just there for emergencies. Then it's assigned to a merits panel of 3 judges. The merits panel of 3 judges is going to basically live with this case for the next many months and read all the papers and do all the analysis and do all the research and make the final big-time decision. And by all indications, this merits panel is very favorable to us because they extended and expanded on the scope of the injunction entered initially by the motions panel. So the merits panel has been assigned, and they have done something favorable, in my view, to gun rights in the Second Amendment, which bodes well. Now, what's interesting is who, again, is covered. Now, again, I think if you're in Mississippi, Louisiana, and Texas, you're probably okay just by virtue of being in that region, because it'd be very difficult for me to see a scenario where the Department of Justice in that circuit, in one of those states, could try to indict someone on a law that has already been found likely to be unconstitutional or likely illegal by the Fifth Circuit Court of Appeals that covers that jurisdiction. So in that geographical region, it would seem to me people down there probably should be covered. Again, I'm not giving you legal advice. I'm just telling you my impressions. And by the way, I have not had a chance to look at every single piece of paper in these cases. I haven't tracked them that carefully. I haven't looked at every reply brief. I haven't looked at the DOJ. I haven't looked at everything here. So that's why I'm not in a position to give anybody any particular specific recommendations or advice. I'm really just flagging issues in this video for you to take up with your lawyers, or maybe the lawyers in this case to consider. Whatever it is, that's what I'm flagging. So that's the first thing. So if you're in those 3 states, probably good news just by virtue of being in the 3 states. Beyond that, of course, if you are a member of the Firearms Policy Coalition, that also looks to be very favorable information, because you are, of course, arguably covered by the membership. Now, I want to draw an interesting distinction because I do think that this is a pretty favorable bit of language for members of the Firearms Policy Coalition, because if you look back in time, this is one of these things that I happen to remember, but back in 2019, there was the bump stock litigation. And why am I getting into that? The reason why I'm getting into that is that was litigated in the District of Columbia in D.C., in part, at least initially on. And I bring this up because there was an emergency motion similar to this brought in the District of Columbia. And initially, there was an administrative stay for maybe a week or so, entered by a federal judge in the District of Columbia. But here's what's interesting. In that case, they said, and I'm reading the relevant language. I'll put it, I don't think I can put a link to it down below because I'm not sure I have links to it. But the date of the order was on March 25th, 2019, in a case called Guedes versus Firearms Policy Guedes, Guedes, Firearms Policy Coalition versus BATF. That's the title of the case. You may want to check it out. But really all you need to know is the relevant language in the order says that the order was, quote, limited the relief granted to the named plaintiffs. Limited the relief granted to the named plaintiffs, which extends relief to the organizations and their bona fide members. So it seemed to me that back then they were trying to play some game by using the word bona fide to intimidate or make it harder to join those groups or whatnot. But that kind of, in my view, limiting language suggesting that, well, there could be a litigation as to whether or not you're a bona fide member, whatever that means. That kind of arguably limiting language we saw in D.C. in 2019 by basically likely an anti-gun judge in the bump stock case is not the kind of limiting language that we see here by the Fifth Circuit Court of Appeals. They say customers and members. So when it comes to FPC, members of FPC are likely protected, it would seem to me, based on the reading of this language. But again, you'll have to consult with, with your own counsel and figure that out on your own. And by the way, one of the interesting questions is if you're a member of FPC, but you're not in Mississippi, Louisiana, and Texas, then, what does that mean for your rights? It seems to me that you have a pretty strong argument that you would be protected under this injunction. That doesn't mean the Department of Justice could not come out and try to argue you're not a member or some other technical argument. Anything is possible, but certainly it would not be the easiest thing on the planet for DOJ to play that kind of a game. Nevertheless, one never knows with what kind of cockamamie arguments DOJ could come up with. Now, beyond that, I want to talk, before I get back to another aspect of this mock case, I want to talk briefly about a pending case in the Southern District of Texas involving the Gun Owners of America and the Attorney General of Texas, Ken Paxton. Specifically, I think the Gun Owners of America have filed a motion, as at least I understand it, I think their foundation maybe, filed a motion in the Southern District of Texas asking that the injunction they received in the district court in Texas, that also be extended to all of their members. So if that is granted, and I don't know why the federal district court in the Southern District of Texas would not, I think that's Judge Tipton, by the way. I don't know why Judge Tipton would not enter that injunction expanding. He already entered an injunction in favor of the plaintiffs in the Gun Owners of America case, in the Texas case, but I don't know why he would not go ahead and clarify that order to be consistent with the order of the Fifth Circuit Court of Appeal to cover members of the Gun Owners of America. That is my guess is what will happen, although I don't think that's happened yet. I think Gun Owners of America has made that request. At least that's my understanding from my review of kind of the public record. And if that's granted, that will be good because, again, then that means in all likelihood, members of the Gun Owners of America organization will arguably be protected from the Department of Justice in the pistol brace issue, at least during the pendency of these cases. So we'll see, but that would be good. So obviously members of Gun Owners of America and or FPC probably are in a better posture than if you're not members. That's probably the right answer at the end of the day. Now there's something other that, now I want to get into something very geeky here and interesting. Take a look at the order dated May 26th, which is the merits-based panel that extends and clarifies the injunction. Remember, we've just talked about members of nonprofit organizations like Firearms Policy Coalition, and in the context of that Southern District case, possibly members of the Gun Owners of America organization. Here's the other interesting thing, and arguably this is actually broader and better for the Second Amendment community than the membership in those gun rights organizations. And that is that the customer definition. Remember, Maxim Defense Industries is in the business apparently of selling pistol braces and related items. And what's kind of interesting here is it specifically says that the customers of plaintiff's Maxim Defense. And I'm going to set aside, by the way, the question as to whether or not Firearms Policy Coalition has customers as well. I mean, they have members, but technically speaking, you could argue they have customers. But set that question about whether FPC has customers or GOA would have customers. Certainly, Maxim Defense would have customers, and those customers apparently seem to include potential customers. Did you hear what I just said? The reason why I say that is because if you look at the order, it says the plaintiffs here include the customers and members whose interest plaintiff's Maxim Defense has represented since day one of this litigation. But then if you go back and you look, and I looked at some of the litigation papers filed by the lawyers for the plaintiffs in this case, and they do have a detailed discussion in the reply papers in favor of Maxim Defense Industries, talking about all the business that they've lost and how they can't stay in business because they are not able to sell, they're having to lay off employees, and this is all irreparable harm. And the reason why I think this is important is if you think about it as a business, an ongoing business, how do you stay in business? The only way you stay in business, you have to keep selling, right? So it's kind of interesting here that because the order applies to all customers of Maxim Defense Industries, I think there's maybe two potential interpretations of the word customers here. One is people that have previously been customers. I mean, if you've ever bought a pistol brace related item from Maxim Defense Industries, that's one interesting question. Are you, okay, I bought them and now I'm a customer and now I'm covered by this? That would be an argument. The other interesting thing is, I don't know what else the company sells, but one wonders whether or not under this order, it refers to just customers of pistol brace related items, or whether or not any customers of Maxim Defense Industries might be able to benefit. So, for example, if they sold, I don't know, merchandise, like a hat or something, well, technically speaking, I suppose, if you bought, a hat or a magazine or a T-shirt or whatever, well, I mean, arguably that makes you a customer of Maxim Defense. At least I could see that as an argument, right? And the other interesting thing, and this is the kind of the broadest interpretation that I think is not crazy, and that is it really is contemplating future customers. So if you're not a customer, but you might be a customer down the road, well, maybe are you also covered? I don't have any of these things, but maybe I want to buy one. So am I now a customer of Maxim because I'm maybe interested in buying one? Maybe I might want to buy one in a month from now. I don't know. The reason why I bring this up, and I don't think my interpretation that customers include prospective customers, people that haven't bought yet but might buy, which would be arguably the entire country, right? Here's why I think my interpretation might actually be the right one. If you look at the footnote number 1 of the order dated 5/26, and this is what I think almost gives the game away. The footnote says the following. It says, one member of the merits panel, remember there's a 3-judge panel, so one member of the merits panel would not clarify the motion panel's order to extend the injunction to customers. See what I said? Would not extend the injunction to customers. The motion panel's injunction was limited to the plaintiffs in this case. There is no authority in the motion panel's order to extend the injunction to an infinite number of non-parties to this case on the theory that full relief to be afforded to the plaintiffs must be permitted to sell products to, ready, to an undefined set of downstream purchasers. Okay, now this is extremely important language, this footnote. This footnote may be the most important part of this entire order from the Fifth Circuit Court of Appeals. By the way, it's a digression. An order is what you have to follow. An opinion is different than an order in a legal case. The order tells you what to do or what you cannot do. The opinion explains the reasoning behind the order. So the order is sort of the binding legal document, and the opinion, which can go on for hundreds of pages, really just explains why the judge entered the order the way he or she did it. So that's what an order is versus an opinion. Today we're talking about really orders here and the scope of those orders, and not about opinions, which we often talk about because the opinions talk about the meaning of the Second Amendment and things like that. So we spend a lot more time on opinions than orders, but today we're focused on an order here, or orders of the court telling people what they can and cannot do. So what's very interesting to me is, again, you have three judges, and one of the judges kind of objected to what the other two judges did. But the two judges obviously are in the majority, so they win. But the third judge raised the question about the scope of customers, because this judge, whoever this judge is concerned that the word customers applies to an infinite number of non-parties, because that's the only way to afford Maxim, right? Or I guess arguably Maxim and FPC, but presumably Maxim, the ability to stay in business. Because Maxim's entire argument is we're going out of business, and if we can't sell these, we're going to go out of business. Which means presumably the only way you can stay in business is to continue to sell. And who are you selling to? Right? Presumably you're selling, if you're in the business of, the stabilizing braces, pistol braces, and your Maxim defense, you're selling to all Americans that are legally allowed to buy these things. And according to this injunction, indeed, you are allowed, at least I can say, if you're a customer, well, then you're protected. And if you look at the relief requested, what they're asking for is the ability to continue to sell these things. But again, it doesn't do any good that, Maxim Defense has the right to sell these items, but no one's allowed to buy them. So that's not really going to give them the relief they need. They can only get their full relief they need as a plaintiff in this case if A, they're allowed to sell these types of objects, these types of items, and someone is allowed to buy these types of items, which is why I think if you read this order that covers customers of Maxim Defense Industries, and you look at the footnote number 1 that actually is trying to say that I would not have done what the panel did because I think it's too broad, but that essentially affirms, right? The objection actually helps clarify that indeed the scope arguably of this order covers all potential purchasers or all potential customers of Maxim Defense Industries, which arguably includes all Americans. I just want to make two other observations. That United States District Court case in the Northern District of North Dakota is important. But why is that? Because it literally covers, I think, like 20 states. I just want to talk briefly about this case pending in the federal court in District of North Dakota, because this could also be a huge victory for the Second Amendment community. The case of this, which we talked about before, is Firearms Regulatory Accountability Coalition. This is essentially, I think, something like 20 different states have sued, presumably on behalf of their residents. That includes states like North Dakota, West Virginia, New Hampshire, and so on. I'm looking at Alabama, Florida, Arkansas, Georgia, et cetera, et cetera. I'll put a link to it down below so you can list the states. Now, presumably these attorney generals have sued under this organization, Merrick Garland, in North Dakota because they want relief for all of the people they represent. And who do these attorney generals of these states represent? Presumably all the residents of those states. So it's interesting. We have to watch carefully to see if an injunction enters out of the United States District Court for the District of North Dakota, because if it were to do so, then the people living in those states would have yet another basis for not having to comply, arguably, with the Department of Justice pistol brace rule. Again, it all turns on what the order says and your situation, everything else, and the jurisdiction you're in. It's, again, far too complicated, too many variables for me to generally describe what can and cannot be done here, but that's another important case. So now I also want to flag one last point about all of this stuff. It is unlikely to occur, what I'm about to say, but I'm going to flag it because, this is the kind of geeky thing you turn to this. And that is whether or not member lists ever become publicly available to the Department of Justice. I think this is probably not going to occur. It's not likely, but I want to flag one theoretical concern, which is that the Department of Justice could, and I don't think they will, and I don't think, because I think there's a ton of reasons why they wouldn't do this argument. It's also unconstitutional. But I could see a situation where the Department of Justice could request of the plaintiffs, something along the lines of, we want to look at the list of all the members so we can make sure we don't indict or arrest those people in compliance with the court order. I think that would not work. First of all, there's series of Supreme Court cases that say donor lists and membership lists and organizations are protected under the First Amendment right of association. I think the recent case on that is the U.S. Supreme Court case 2 years ago. I think that's Americans for Prosperity was the name of that case. Nevertheless, First Amendment protections of donor list and membership lists, but the Department of Justice could come back and say, well, we need to know who's involved in these lawsuits because we want to make sure we're going to comply with the injunction. That would obviously be objected to, I presume, and say we're not going to turn over our donor list or our membership list to you. Beyond that, if you think about it, the membership list would not necessarily be relevant to the question, or they'd be partially relevant because there's certainly plenty of people that I'm sure are members of these gun rights organizations that have nothing to do, they might not even own guns, right? You can become a member of a gun rights organization and not own guns. It's no different than, people might become a member of Planned Parenthood to support abortion rights, even though they are not able to have kids or can't get pregnant, for example. So, I think that to disclose membership lists would be over-inclusive because it include a lot of people on there that don't even own stabilizing braces. And again, just because they're a member doesn't mean they would be impacted by this. But you could see DOJ trying to do something like this. The other thing is I think it would be barred under what's known as the unconstitutional conditions doctrine. That what that means is you cannot be forced to give up one constitutional right to exercise another one. So to the extent DOJ tried to say we want the membership list of these organizations, I think the right answer, one of the right answers would be, sorry, that is a violation of the longstanding unconstitutional condition doctrine, because you're basically saying that the only way these people can exercise their Second Amendment rights to keep and bear arms, which is a constitutional right, would be to give up their names to the government, which essentially is a violation of their First Amendment rights. You can't force us to give up our First Amendment rights in order to exercise our Second Amendment rights. So I think you would have a very strong argument in that context. And again, I think that if the Department of Justice wanted to do any of the things I'm just describing, they would have to file a motion in the Fifth Circuit Court of Appeals trying to get this clarification, trying to get this information, and I think that would be a stretch for them to succeed on that. But do be aware of that possibility. I don't think it's a high likelihood, but you come to this channel for sort of the geeky inside baseball stuff, and I try to provide that to you. All right, folks, I hope some of those issues and considerations and thoughts help you think through your various situations with the pistol brace rules. Obviously, you got to consult with your own lawyers, your own counsel, the relevant plaintiffs in this case, or these cases to make your own decisions. But again, I'm just flagging issues and things that I'm observing for you all to consider and carry on. Okay? If you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon at the Four Boxes Diner.
Orders up. Table 2A.